Hi, everyone. We're going to go ahead and get started. Thanks for participating in the webinar today. Today's a big day in labor law, and the NLRB ambush election rules are here. They are upon us. They're effective today. And so we thought this would be a good opportunity to remind everybody about what the rules say and what you need to be doing within your company to make sure that you're prepared. You know how to respond to the new rules, what your obligations are, and what the new things you have to do to comply, and more importantly, you know, what you should be doing now before any union potentially files a petition to represent your employees. So today we're going to go ahead and get started. The agenda is really straightforward. You know, I'm going to touch on pretty briefly a couple of the legal challenges that have been raised to the NLRB rule, both at Congress but also in the courts. Most of the webinar, however, will be focused on the timeline and the process for the new election rule, and we'll really go into some specific detail day by day as to what events are going to occur, when they occur, and what you need to be doing to make sure that you put your company in the best position possible to respond to the petition. And then we'll close with strategies for responding to union organizing and what things you can be doing proactively with your employees and with your management team right now to fend off any potential organizing, because you know, that's the ideal world, is that we never get to a point where we're ever responding to a union election petition. We hopefully may have some time at the end for questions. As I mentioned, I have muted everybody on the line, but if you do have a question, please post it in the chat box and we'll try and address it at the end. And otherwise, you can always reach out to either Lindsay or I if a question comes up after the slides and the presentation is done, and we'll answer them then. We will make the slides available to everybody, as well as a copy of the recording. So if someone in your company was unable to attend today, or you think someone might get some value of the information that we're providing, feel free to circulate the recording as well. So let me touch on first the, what the legal challenges are to the NLRB election rule. There was a congressional attempt to block the rule. On March 19th, Congress passed a resolution that would block implementation of the rule. The resolution was developed pursuant to the Congressional Review Act, and it passed both the House and the Senate with the Republican-led Congress. However, President Obama publicly stated that he would veto it, and he did in fact do so on March 31st, and there just isn't enough support to override his veto. So it's a little symbolic, but the point of it was to really emphasize and show the President and the NLRB itself, the public pressure and public response to these rules, and that it's really anti-business and it's hurting business and hurting, ultimately, helping unions and not employers. But at the end of the day, that's where we are with that act. There are a couple of legal challenges pending in 2 federal courts currently. The first one is the U.S. Chamber of Commerce's lawsuit that's pending here in the Federal District Court in Washington, D.C. And they filed a complaint essentially asserting that the NLRB exceeded its authority under the NLRA by enacting the rule, both under the Fifth Amendment and the First Amendment under the U.S. Constitution. If you may recall, there was a similar lawsuit back in 2012 that hit and attacked the original first rule for the same reasons, but that argument ultimately never reached the merits on the constitutional questions because the issue was raised based on the lack of quorum. If you recall, the Craig Becker recess appointment issue took center stage, and ultimately that's how the rules were struck down under that reasoning. So now we're back again, round number 2, and the Federal District Court is considering the questions on the merits. There's a second lawsuit also that was filed in Texas by similar business groups, and both those cases are currently pending. Probably the one in D.C. is going to be resolved first. Both parties have filed cross motions for summary judgment, with the chamber filing first. And that brief is fully briefed and waiting for a ruling from the judge. we were hoping that the judge would either issue a stay of the rule pending the ruling on the motion for summary judgment, so that it would not become effective today, but the judge did not do that. So at this point, we're just waiting on the ruling from the judge. I don't know if the judge will take oral argument on the briefs or rule just on the papers, but certainly that is something that we are watching closely, and we'll be alerting everybody as to what happens when a decision does come out on that rule, and hopefully we'll strike down the rule. Obviously, anybody who loses at the district court will likely appeal to the D.C. Circuit. The D.C. Circuit recently has been very critical of federal agency overreach and has struck down other rules, not only before the NLRB, but other federal administrative agency rulemaking. And so we would expect that even if the chamber loses at the trial court, they would appeal to the D.C. Circuit, and even potentially going all the way back up to the Supreme Court, because this is obviously an issue that the administration feels strongly about. And as other rules and other issues before the board have proven, they take it all the way up to the Supreme Court if they need to. So this could be a long, drawn-out legal battle. Interestingly, if they are successful in striking down the rule in D.C., there will be a question about whether it only applies to employers that are in D.C. and whether the other regional offices around the country, if the rule is still effective in those regional offices. So still a lot to be learned from these lawsuits, but the most important thing is let's not wait to hear what happens, and let's start acting within our companies as if this rule is here for a while and what you need to be doing to prepare. So with that, I'm going to turn it over to Lindsay Smith, who's going to talk about the first few things you need to be aware of with the timeline and the process under the new election rule.
All right, I'm Lindsay Smith. Good afternoon, everyone. So I'm just going to take a little bit first to talk to you about the impact of the election rule, just briefly go over what we see as the biggest consequences of this rule being passed, and then we'll go through a step-by-step process of how the election rule actually works. So as Kara said, this rule does become effective today, April 14th. And as she talked about, there are legal challenges against the rule, but as of now, they have not been successful. So as of today, this is the new process. And one of the first things that we see and is very significant for employers to consider is the fact that this rule will substantially shorten the time between when the union files its election petition and the actual election date, which gives employers much less time to prepare and to really express to their employees exactly what their position is on the election. It also substantially limits the opportunity for full evidentiary hearings or board review on contested issues. So several aspects of the rule actually put review of issues into the discretion of either the regional director or the board. So they can decide whether they want to address these issues or not, and oftentimes they will likely be pushed off until after the election actually occurs. And some of those issues and some of the main ones that we see that would likely come up beforehand that would really be beneficial to address before an election is whether the unit is even appropriate, voter eligibility, and any sort of election misconduct. So some other consequences that we see, and I kind of touched on this a little bit a minute ago, is that this really erodes the employer's opportunity to communicate its position on union organizing, which we view as quite unfair because the union will have months. It knows that it's attempting to file a petition for election. It knows when, it will likely do so. So it can really take advantage of the time before it files its petition to, spread its message to employees, often, misleading employees, and disseminating propaganda and information that, in which it expresses false promises and really expresses things that may not be true of the employer. And the employer will not really have as much of an opportunity in such a short period of time before the election to express that that's not the case or to express its viewpoints on the issue. And then finally, it denies employees' ability to make informed decisions about unionization. Because of the lack of information that it would get from the employer side, it's going to be a really uneven playing field before the employee will actually have the opportunity to vote, and they may not have access to all the information they need to really make an educated decision as to how they will vote. So now we're going to go into the actual election process. So what you see on your screen right now is a flow chart that we have put together to express the steps in the process and what we kind of see as the main points in the process. And what Kara and I will do now is just take some time to go through each one of these steps. So the first step and what kind of triggers this whole process is that the union files the petition. So they'll file it with the NLRB regional office, and it can be filed by either email, fax, mail, or in person. And the electronic filing is really, a significant change here because, again, this kind of speeds up the process and makes it very easy for the petition to be transmitted to the regional office. When it transmits its petition to the NLRB, it must provide a showing of interest just to substantiate that there is, in fact, a potential voting unit. And the NLRB rules actually require the union to serve the employer in the same manner that it serves the NLRB or in a more expeditious manner. So now that the NLRB can serve the petition electronically to the NLRB, it can also actually serve the petition electronically to the employer. And this would be the most expeditious method under normal circumstances. If the union cannot file electronically with the employer, if they don't have the necessary information, then they can use any of those other methods to do so based on how they filed with the NLRB. So the petition may also be filed with the employer by fax, and it could also be done through personal service the next day after the petition has been filed. If the union does do personal service for the employer, they are expected to call the employer the day the petition is filed to let them know that they should be expecting service the next day. Once the regional office receives the petition, it will issue a notice of hearing. If it determines that there is sufficient showing and representation, and it otherwise finds that there are no issues with the petition going forward. So after the NLRB makes the determination on the petition, the next big step in this process is the posting of the notice of petition. So after the petition is received, the NLRB makes its determination. It will serve on the employer not only the petition itself, but a notice of hearing, a description of the procedures for the election process, the statement of position form, and the notice of petition for election. The NLRB will serve the petition through regular mail and mark the correspondence as urgent, which is an important thing to note because that's something that an employer should be looking for. It will also, however, send a copy of the materials listed by email or fax if it has the employer's information to do so. If the NLRB does not have this information already, it must at least attempt to obtain either an email or fax number to try to send that information to the employer to make sure it's done as expeditiously as possible.
I'm just going to interrupt you for a second because I'm hearing that we are having some sound issues. So what I'm going to suggest is, to the extent anyone is using the online audio, maybe just try dialing in through the phone and the phone number, and hopefully that will work. And then keep letting me, please let me know, and through the chat feature if that helps, and we'll keep going. Okay, go ahead.
All right. So definitely let us know if you're having any issues. We want to make sure everyone can hear the webinar. So going back to the notice of petition, the date of service actually starts the clock for the rest of the election process. This is very important for employees handling the mail, their managers, and anyone else likely to be contacted by the NLRB or the union to let them know that they should be expecting service, such as those in your HR department that they all be trained that anything from the NLRB must be immediately transmitted to a designated representative who will handle such matters. For example, if you're head of HR or a specific supervisory employee, or even, if you have a committee that deals with election matters, they should be assigned as the point person for all of these election-oriented matters. And your employees that may receive information from the NLRB or the union should know who to contact, be trained on who to contact, and make sure that it's very clear that there has to be open communication as soon as anything comes in. As we said, the process is a lot quicker now. And because of the fact that the union, there's an expectation on the union to transmit the petition immediately. It could come, like we said, electronically. You could receive a phone call that you should be expecting service. You'll likely be put on notice that you are receiving the notice of petition before you actually receive it from the NLRB. So it's really important at that time to just kind of remind everyone that this is something you need to be on the lookout for because it starts the clock. So the notice of petition must be posted immediately. The NLRB has expressed that immediately means within 2 business days after service, and it has to be posted in conspicuous locations, which means all locations where notices to employees are customarily posted, and all pages of the notice of petition, if it is more than 1 page, all pages must be posted in a manner that they are simultaneously visible. You must also disseminate the notice in any manner that you usually transmit such information to employees. So if you usually send things to employees electronically, then you should do so with the notice. So this could be through email or on an employer's intranet. An interesting part of that, though, is if you only customarily communicate with some employees electronically, those are the only employees who must receive the notice through this method. And then, just as a final note, failure to post the notice may be grounds for a rerun election. So the next major step in the process is a statement of position. And this is usually due around the 7th day after you've received service of the notice. So unless the case presents unusually complex issues, the hearing on the petition will be set on the 8th day after service of that notice. And this documentation will actually specifically specify the due date of the statement, but it will likely be on that 7th day, the day before the actual hearing takes place. If the hearing, however, is set to begin beyond 8 days from the date of service, then the regional director can set an earlier due date for the position statement, but it must provide employers at least 7 days notice before the position statement would be due. And that position statement will be due by noon on the due date, and noon will be based on the time zone in the region issuing the notice of hearing. In the statement of position, and this is the really important part and the part that we think is pretty controversial about this election rule, the employer must address any issues with the representation proceeding itself, as well as anything else it would wish to litigate regarding the election process. And employers' arguments will be limited to those that are set forth in the statement of position. So if any issues are not raised in that statement, then they will likely be waived. Although there is very limited circumstances in which the regional director could allow a party to amend the position statement for good cause, this is limited. And so it is very important that all of the major issues do make it into that statement of position. The only thing that the NLRB has explicitly expressed would be allowed to be raised if it's not actually stated in the statement of position are questions of jurisdiction. But that, again, is very limited. So it's important that anything that the employer would wish to litigate is included in that statement. And again, this is one of those problematic changes that we see because it gives the employer potentially only 7 days to address and develop arguments for all potential issues associated with the election, which really doesn't give much opportunity to, develop the argument, to determine what the issues really are, and to make sure that all of them are covered in this one document. And I think, we perceive that this could also cause things to be put in that really aren't relevant to the representation proceeding, but are just thrown in to make sure that, there are no arguments lost. And we don't think that is a particularly effective way to, address the issues surrounding the representation proceeding. So the next slide just gives all of the information that must be put into the statement of position. The NLRB's jurisdiction should be addressed. Any contention that the petitioned for unit is not appropriate. The existence of any bar to the election process. Type, dates, and times and locations of the election. So the NLRB would like the employer to provide, some information what they see when the election should take place and where. Names of employees in the voting unit and their work location, shifts, and classifications. And then, like we said, any other issues surrounding the representation proceeding. Going back to any contention around the petition for unit, if the employer contends the unit is not appropriate, it must provide the basis for that contention, as well as the locations, classifications, and groupings of any employees that it believes should be added or excluded from the voting unit. And that list of employees in the voting unit and those in contention must be submitted to the NLRB electronically. And it's interesting, the General Counsel recently has stated that the expectation will be that the information is presented in a searchable format in a Word document or through a program compatible with Word. And then the position statement itself may also be electronically filed, but you have to make sure that if it is being filed electronically or by any other method, well, specifically electronically, as this would transmit immediately, that the position statement is received by or before noon on the day before the hearing.
Okay, so I'm going to take over and talk about the petition hearing and the next time frames going through to the election. A lot of, as you can imagine now, just in that first week, a lot of flurry of activity between receiving the notice of the petition, having to post the notice of petition, gathering the information that you need to submit the position statement, and then prepare for a hearing, which is going to be held at the earliest on the 8th day after service. So not a lot of time from the minute you realize that your company is trying to be organized. Essentially, the regional director has discretion to determine whether there's a question of concerning representation at that hearing, and if there's no question and no other bar to an election, he's going to issue an election, direction of election without holding a hearing. And particularly as it relates to unit eligibility issues, likely will no longer be litigated in this hearing. And the other thing to realize is that during this time period, day 2, day 3, day 4, day 5, you're going to get calls from the regional director almost daily, if not more, throughout the days, and they're going to try and narrow any issues for a hearing. It's the regional director's goal not to have a hearing at all, and to just direct an election. So to the extent that he can narrow these issues concerning the question of representation, and if there's no other bar to an election, and the parties can, consent and agree to stipulate to the jurisdiction and that there's no election bar and all these other issues, then he's going to ask the parties to enter into a stipulated or some other consent election agreement without holding a hearing. So you've got to realize that before, where a lot of companies strategically use the question of unit eligibility as a way to get to a hearing to further delay the process to an election, which gives an employer more time to campaign and get its message out about unionization, that time period now is getting shorter and shorter, especially in light of the fact that there might even not be a petition hearing. If only voter eligibility remains as the question, the hearing officer will likely close the hearing. It's not no longer an automatic bar to proceed if you've got more than 20% of the employees who may have a question about unit eligibility, and the hearing officer has his discretion to create subset groups, and if each of the subsets is less than 20%, same thing, they can defer that question of unit eligibility to later in the proceeding after the election. So let's say there is a hearing. After that, there's going to be a direction and notice of election, and that can occur anywhere from day 8 to day 10. The board has not set a firm date when an election has to take place. All they said is that it has to take place at the earliest date practicable. So before an election, you've got a notice of election must have been issued and received by the employer so that employees have the necessary voting information. This really is going to, again, shorten this time period for the same reason it's going to be likely transmitted to you electronically or more quickly. It could theoretically be issued the same date as the hearing, although practically probably not. It probably would be issued the next day. So once you get the notice of an election, just like you got the notice of the petition, you're obligated to post it, and it has to be posted in the conspicuous locations, same places that you would post your other regular workplace policies and procedures and posters for 3 full working days. And then within 2 business days of the direction of election, you need to prepare what we call the Excelsior List and submit that to the union and the NLRB. Previously, it was up to the NLRB to circulate the Excelsior List to the union, and now with the new rules, the NLRB has shifted that burden over to employers, and you're going to have to submit that to the unions in the same way, often probably electronically again. If you fail to post the notice, just like failing to post the notice of the petition, it could be grounds for rerun election. So you really want to make sure. This seems like a silly, small issue, but it has some important consequences if it fails to get posted. So you really want to make sure that these posted gets posted. The Excelsior List has to be received by the regional director and the union within 2 business days after the direction of the election. And again, failing to serve the Excelsior List similarly could result in a rerun election. So these time frames are important, and that's why we've set it out this way, so that you really understand what you need to do each day so you don't risk having a rerun election, because there could be nothing worse than you having running a strong campaign and winning the election, and then for some small technical reason, there's a rerun election and you have to start the process all over again. So here's the information that's included on the Excelsior List. It's essentially a voter list. It's a list of the employees that are in the voting unit. If to the extent that you have agreed upon the voting unit, either through a stipulated election agreement or it's just been determined through the hearing, you want to list everybody in the voting unit. If there are employees that you contend should be included in the voting unit, but whom are either voting subject to challenge or the issue of their eligibility has been deferred until after the election, you need to include them on the list as well in a different location. You need to include their home address and their personal contact information, which includes their personal cell phone number and personal email if you have it available. So we've gotten a lot of commentary about that, and this is one of the issues that we argued before the board as being an unreasonable burden on the part of the employer, because you may not be collecting, as a matter of course, your employee's personal cell phone number or their email address, but they may have provided it to you through the payroll system in order to facilitate electronic payroll, or maybe a supervisor happens to have a cell phone number in order to call in employees to work or otherwise communicate with employees. If you have supervisors and managers who have that information, it needs to be disclosed on the Excelsior List. So one of the things that you should be doing now is pulling together in a readily accessible way all of this information so that it is available right at your fingertips, if we're in a situation where we have to provide it to the board and to the union. Also disclosing employees' work locations, their shifts and their classifications. That goes to, an issue again about unit eligibility as well as when they work, and essentially it's a roadmap of how the union can get in touch with these employees if they haven't already been communicating with them. Another thing that we were very concerned about in commentary filed before the board was the use of the Excelsior List. This contains employees' personal information in addition to their home addresses, which the union always got, but now emails and cell phones, and we were very concerned about employees' right of privacy to that information, especially since they've not consented for the employer to disclose that personal information to third parties or to the government. And so what the board did in their attempt to resolve that issue in the general counsel's memorandum is that they've said that it's limited to the use for purposes of the representation proceeding or any appeals or anything like that, and it specifically cannot be used for harassment or coercion or to steal from employees. And then they side noted that to the extent there are any kind of abuses of the Excelsior List, that really should be handled through an unfair labor practice proceeding, which a lot of people don't think that is sufficient. There are also similar to the position statement. It also has to be provided. This information has to be provided in a table in Microsoft Word or in a format compatible with that, so that it can be searchable and really easily formatted for the union's use. Okay, so from day 10 to day 20, the union has received the Excelsior List, and it has 10 days to use the information before the election can be held. But importantly, unions can waive this 10-day period. And if you think about it, they're likely going to waive it because they probably have been organizing the petition for unit for months, as Lindsay mentioned in the very beginning, and they probably have received most of this information. That at least they've gotten contact with at least 30% of the unit, because that's who they had to submit for the showing of interest. So they might not need the 10 days to use the information on the Excelsior List, and so the elections can be held pretty quickly after day 10 if the union does decide to waive it. That would significantly then move along the election, which could be in the union's advantage as well. All again going to the overall concern that the rush of this quickie election rule means that employees, ultimately who the National Labor Relations Act is designed to protect, employees do not have enough opportunity to have a free and fair and fully informed vote in a secret ballot election about whether to be represented or not by a union representative. So the election can be held, as I mentioned, as soon as day 11 if they waive the 10-day period after receipt of the Excelsior List, or up to day 21. After the election is held, you've got some time to file a post-election objection, which is within 7 days of the tally of the ballots. And if you've got a hearing, it'll take place 21 days after the tally of the ballot. So that just gives you more opportunities to pull together all of the arguments that you need to be making for purposes of potential post-election objections, whether that's some kind of unlawful conduct that happened during the election, or some other issue, supervisory issue, that you want to file as an objection. The regional director can make his post-election rulings, and then the board does have discretion to deny any further review of those rulings under the new rules. So before I get to the strategies for responding to union activities, I want to answer a couple of questions that came in on the time frame. The first one was whether day 1 is the day that the call is received, letting the employer know of a petition, or is the day that it's actually received by the employer. And day 1 is the day that service is made by the NLRB with the notice of the petition and the other documentation. So the fact that you may have gotten a call from the union the day before giving you a heads up that they filed the petition, that is not the triggering clock for all these other deadlines. What triggers these deadlines is the service date from the NLRB, and that could be, again, either electronically to you or another way, but that's the day that starts triggering all these other deadlines. Another question came in, which was, I think that is it. I think another question was, if you're open 7 days, is the 2 business days mean 2 of your working days, or do you count weekends? And if you're open 7 days, the 2 days would continue to count as your business days. Okay, so the last 10 minutes or so, and then I want to open it up for additional questions. I want to go over, some strategies for responding to union activities, because if you haven't realized it yet, if you're receiving a union petition and you haven't really talked to your workforce about making sure that your employees in your workplace is a happy place to be, then it's almost a little too late. It's just, with these election rules, with potentially an election happening on day 11, but certainly possibly within 3 weeks, you just don't have time to adequately campaign and get your message out to your employees during this process, because you're going to be working very hard with your outside counsel, with your operations team, with your other members of management to pull together the information you need to put in your position statement. You're communicating with the hearing officer to decide whether you're going to go forward with a hearing. You're preparing witnesses to testify at a hearing, and then ultimately you're preparing for an election. And so if you haven't implemented really proactive strategies now, it's really, really going to be hard to overcome a union election. And that's why it might be, time will tell as to whether the unions start to reinvigorate their preference for union elections. There are some unions, particularly in the hospitality industry, that in recent years have gone back and really focused on card check agreements and neutrality agreements as a way to force employers into unionization without an election. And that was, again, part of the Employee Free Choice Act that got such public outcry that ultimately led the board to issue these rules. And so I wonder, rather than having to negotiate and fight over a card check agreement, unions may say, I'm more likely to be successful with these new election rules because they so favor unionization just with the timing element, hoping to catch an employer off guard. I think unions are under the misguided impression that employers are aware that their employees are being unionized. But, in countless hearings and countless election proceedings that I have handled and people that I have questioned on the stand, union representatives and people who are organizing, the organizing agents, they are trained to keep their efforts secret. They do organizing meetings outside of the workplace, outside of normal working hours, at people's homes. They don't want the employer to know that it's going on, particularly because they want to protect the employees from potential retaliation. But they also are trying to get as much support in a way to make it a surprise to the employer. And so I think that with that continuing and then having such a short time period, it's going to be imperative that you've got some strategies in advance for responding to the activities. And a lot of that is just good, honest HR, employment relations training. I mean, it's things that you guys do on a day-to-day basis to make sure that you have a happy workplace. You've got, competitive and fair wages and benefits. Your managers treat your employees with respect. You've got, potentially an internal grievance procedure, an open door policy where people can feel comfortable to air complaints or grievances and feel like they're being heard if it's not, resolved to their satisfaction. But in any event, you've got a place that is working well. And so keep those up. That, when talking to your C-suite executives, make sure you're putting ample resources into your HR budgets to keep up that strong, positive HR training and communication strategies with your employees, because it also is part and parcel to a union avoidance strategy. But you also want to, one of the things we're recommending is kind of put together a high-level management team. This could be, depending on the size and structure of your organization, as few as a handful of people or, more people than that. But you want to have your HR person involved. You want to have maybe accounting and finance, someone in operations, people who have access to the information that needs to be disclosed on the Excelsior List, someone who is going to be, the primary contact person from the union or from the board, whoever they're going to try and call within your organization. You want to make sure they're included on the team so they know what to do if they receive a call from the union. You want to, make sure you've got this team and that you have a plan in place to respond to organizing, so that you're not caught off guard when you receive that call and when you receive the petition from the NLRB, that you already know what your unit looks like. You already know where those people work, what their shifts are, what their hours are, so that you can pull the information together. If you have in-house legal counsel, you want to include them on it, or your outside counsel, so that you want to make sure you're starting to marshal the legal arguments that may need to be set out in a position statement, since you have such a short amount of time. And in part of that team, you want to think through what would be an appropriate bargaining unit at your company. Is it a single site? Is it a unit within a single site? Is it types of employees, or do you cross-sell and cross-train your employees? So you've got employees doing lots of different jobs, and you may want to have a more expansive unit than maybe a very small unit that the union might try and organize. If you have an understanding of what those appropriate bargaining units are, and you have the data to collect to support why that's the most appropriate bargaining unit, that will go a long way in your arguments for unit eligibility. Even if it's not something you might be able to raise at a hearing, what you have to put into the statement of position, and it really will help you marshal your arguments and be effective. You also want to develop a communication plan for your managers and your employees. And your managers need to know the do's and don'ts of union organizing. There may be managers that are being promoted up through hourly employees, and they've never been a manager before, and they don't know what union organizing is, and they don't know what they can say to employees in response to organizing. So you want to make sure that they're adequately trained and supported so that they don't fall into an unwary trap of an unfair labor practice. And you also want to make sure your employees, again, understand the great benefits and part and parcel to why this is a good place to work, and they don't need to be seeking out a third party for representation. But you need to understand what you can say to your employees, what you can't say to your employees during an organizing drive, and what could be considered an unfair labor practice. And then, because the time frame is so tight, it's really important that you have a really good calendar and timekeeping system so that you can track the dates and the deadlines, and making sure that you don't inadvertently fail to post a posting or miss that noon deadline for your position statement. Whatever it is, that you are really tightly controlling the dates and deadlines. And then you want to think about, some other proactive labor strategies and some of the stuff I've talked about, the do's and don'ts of union organizing, what you can and can't say to your employees. You want to conduct that through management training. You can do broad level management training. You can do focused management training by department, by certain managers. One of the things that we think is always good is to develop a top 10 list and have your employees kind of polled and questioned in open forums and say, look, how are we doing? Let's do a checkup. How are we doing as an employer? And if you could change anything, what would you change? Or are there things that you want to see improved about this place? And I think what I like about those trainings and those meetings, and doing it at a smaller level, like department level or division level, is that you can really identify whether you have a systemic issue that might be a bug in someone's ear for throughout the company, like maybe it's a vacation policy, or maybe they don't understand something that's going on, or is it just a one-off issue that's affecting one department and you can quickly remedy that. That if you're doing those kind of top 10 list issues and collecting that information and understanding where people's gripes are and if they can be remedied. It's just a great way of following up with your employees, saying, we've heard you, here's how we can help you, here's what we can do, here's what we can't do. But most importantly, we've heard you, we respect your concern, and we will take steps to make sure that you are happy here. If you do all that, it's less likely that a union will be successful in finding someone who's willing to support their campaign. No solicitation policies. You want to make sure you're enforcing those to make sure your employees are not soliciting other employees during working business hours. That became a little bit more complicated with the new electronic rules that came out recently from the board that says that employers and employees can use electronic systems, including your business email, for organizing purposes. So be up to speed on those rules, and we can, people have questions about that, we can talk about that offline. And then, it's always good to do a wages and benefits comparison to make sure you're competitive in the marketplace. You probably do that anyway. Although in reality, wages and benefits are a small percentage of why people organize. It's really about, respect and dignity and being heard. It often is organized by language issues or using racial issues in the workplace. Those kinds of contemporary issues, so to speak, are what drives organizing versus the more traditional wage benefit, issues. So that is our presentation. If anyone has questions, here's our contact information. I see we have a couple of questions coming in also through the chat, so let me see if I can answer them. One is, do you have top 10 list of questions you can share on the do's and don'ts? We do. We do have things of what you can and cannot say to employees, but just off the top of my head, I'm going to tell you an acronym to remember, and that's TIPS. TIPS. You cannot threaten, you cannot promise, you cannot interrogate, and you cannot surveil. Right? TIPS. Yep, those were my 4. So within that, you want to make sure that none of the statements that you're making to employees has an implication that you're somehow threatening employment or threatening a raise or anything kind of a plant closure, anything like that that would affect terms and conditions of employment. You also want to make sure you don't make any promises like, hey, if everyone votes the union out, everyone will get a raise next year, things like that. Surveilling, you don't want to be taking notes of who's attending meetings, who is supporting of the union, and those nature. And I can give you more detail, Lee, about the do's and don'ts. Another question is, how does an employer know who's eligible for receiving service? What level of management? Registered agent. So, it's not as simple as your legal registered agent. Anyone who is a manager binds the company and so would be authorized to, sort of quote unquote accept service, which is one of the things that in terms of card check agreements you want to be very careful about. But they're going to probably try and contact, the highest level within the company, whether it's the general manager or it's the, director of HR or, somebody at a senior level management, either by phone call or through the, through the NLRB process. But it does not have to be the official registered agent. And, unfortunately, any level of management is someone who binds the organization. Another question is, would they be likely to take the tactic to deliver service on a Saturday when HR is generally not there, thereby reducing the days to 10 days by the time Monday comes? So the board is the one who, issues the service, and so they would have to, they're not open on Saturday either, so they would probably, try and either issue it electronically on Friday, and or call you guys, and then personal service, if you're closed, that won't work, so it would have to be personal service on the following Monday, just letting you know that it's there. So I think if you guys are closed, the tactic would be, getting it to you when it's open. They probably would try and phone you and get that information to you electronically on a Friday versus a Saturday or Sunday. C. What if your managers and supervisors sign a code of conduct that says they cannot bind the company? Does this take away their ability to be served, or would they still count because they are management? You know, they're still technically management. They're supervisors, and one of the reasons that you would want to make sure they're supervisors is that they're not eligible to vote in an election. So, you know, I think one of the things that I've always counseled employers on when it comes to accepting potential authorization cards in a neutrality or card check agreement situation is that the manager says, look, I'm not authorized, you know, I can't take this call, I'm not authorized to accept service, you need to contact so-and-so. So there should be someone designated in your organization that your managers can tell either the union representative on the phone or the board or, you know, hearing officer, look, you need to contact this person to discuss this matter. And that's part of something you should have in place as part of this committee and planning process so that your managers know who to direct the right person to. Technically, as management, they bind it regardless of a code of conduct agreeing not to, but the best probably practical way is just to let them know, hey, I'm not authorized per my company's policies and procedures. Please contact, you know, Jane Smith. So those are at least all the questions that have come through on the chat. I'll give it a few more minutes, but again, as I mentioned, the recording will be available to everybody, as will the slides. And we do have the chart, the timeline process in a larger document, in an 8x11 larger form, so you can get a copy of that. We can send it to you if you're interested in it, rather than looking at that one slide, and hopefully that'll be helpful to you as you guys consider and understand what the important dates are. Okay, so if I don't have any other questions, thanks everybody for participating in today's webinar. I hope that you found the information helpful and that you guys are at least a little better armed to respond to the new election rules. And if either Lindsay or I can be of assistance in either training your managers or helping you better understand the nuances of the new rules, please don't hesitate to reach out. And we hope everyone has a great rest of their day. Thanks very much.